Well, the presiding judge is expected to hand down judgment at 8:30. This is just 30 minutes before the airing of the much-anticipated documentary. The lawyer representing Thabo Bester argued that the convicted rapist and murderer will suffer prejudice in his right to a fair trial, human dignity and his right to be presumed innocent until guilty, should the documentary be allowed to be flighted.
We are saying such documentaries carry a weight into the public court, carry a weight into the public opinion and interest of the people. And also, my lady, hear my argument within the context of everything that I've been saying for past 30 minutes or so. I have already said, in this documentary, we have the accused, one of the co-accused, who is speaking, the father of Nandipha Magudumana. I'm repeating that. And she says, I could not imagine my daughter doing such a thing. It's left there so that people can go and watch the documentary to hear what such a thing will my daughter be doing. And now we also have a judge, Justice Cameron, speaking in that documentary, saying, as a judge, I have never seen such a thing. What a thing is that? Definitely we are talking about Thabo Bester's alleged escape, which already the answering affidavit have stated that this documentary is about that. Now my argument says, when such documentary are flighted or broadcasted, we then are standing in one corner of the truth, because he is also not given a right of reply.
But lawyers representing Netflix lambasted that argument.
The statement from the father of Dr. Magudumana, who says that I cannot imagine that my daughter would do something like that. It's actually nonsensical to claim that that statement implicates Dr. Magudumana in anything. If anything, it's an exculpatory statement, because the father says the allegations are just not believable. And there's no statement there that says that she is guilty of anything. If we go to the second statement by Judge Edwin Cameron, the statement is simply that it's the most astonishing thing that he has witnessed in his life, or indeed as a judge. That again is a neutral statement. It does not implicate anyone in any wrongdoing. And then we go to the third question from the commentator or the narrator, who says that rhetorically, is Ms. Magudumana an accomplice or a victim? Now what our learned friends are saying, that you must read into that it implicates Mr. Bester. But it simply doesn't. It's a rhetorical question, whether or not she is an accomplice or a victim. All of those three questions will be dealt with in the trial. So when you look at the content of the statements themselves, the content of the statement is neutral. It does not implicate anyone, and it doesn't suggest that there is a statement of guilt in whatever manner whatsoever.
Well, the High Court in Pretoria also heard that Nandipha Magudumana entered into a commercial archive license agreement with the production company StoryScope for the use of archive photos of her life. But her lawyers say the agreement is not enforceable, and that by the time she signed that agreement, she had not appointed a power of attorney. They say Magudumana also wanted to view the documentary, but that did not happen.
Netflix then responded only on the 31st of August 2025 to the letter of demand. And obviously they reiterate that she can't come to court because of the contractual clause, and particularly at paragraph 6 of that letter, which is found at page 001-136. That is the page number. Paragraph 6 of Netflix response says that Dr. Magudumana has also concluded an archive licensing agreement with our client, in terms of which she agreed commercial terms with our client for the use of her personal archives in the production of the documentary, and that she has waived the right to interdict. She has waived this right that we're trying to do. The right that she has in terms of Section 34 is simply access to court. She has waived it.
They seem to suggest that they have a right, effectively, to veto the documentary. If they said no, the documentary wouldn't be published. But there is no subject who has any entitlement to veto a story about them, particularly a notorious figure. Otherwise, if you started giving people the right to veto a story, no adverse stories would ever be written about anyone. Then you have an issue about prior comment. There is no right in South African law of defamation that a subject of a story is entitled to comment before the story is published. And no right is established here at all. What has happened is that Ms. Magudumana has distorted the contents of the agreement and suggested without any evidence that it gave her the right of veto and prior comment, but it didn't. But she was, in any event, invited to comment. She was invited to give her own story on the documentary, and she elected not to. It is obviously a factor that it has made a commercial investment to the production of the documentary, and it has done so with the knowledge and participation of Ms. Magudumana in circumstances where she was paid for the use of her archive material. And it is therefore unacceptable for her at the last minute to turn around and say, I don't know what you are doing. What she has actually done, she was represented by Mr. Mgudlwa, who signed the power of attorney, and Mr. Machini Mutloung.
Crisalda Lewis, SABC News at the High Court in Pretoria.